So you're a first-time home buyer. You found your perfect dream home. You met with your realtor. They showed you the place. You love it. You made an offer. It got accepted. And now your realtor and your family is like, run to the lawyer's office, sign the contract so you can buy this house. Before you buy that house and you sign that contract, let me explain to you the 5 things you need to know and understand about signing a contract and its obligations when you're buying a house. Hi, my name is Mohammad Saleem. I'm an attorney. I've been practicing real estate law since 2010. And in this video, in 5 minutes, I'm going to explain to you all of your obligations and some of the 5 most important things I think you need to understand before you sign that contract to buy that dream home of yours. So to begin, the first thing you need to understand is that when you're buying a house, for majority of people, they're not going to be able to buy the house with all of the money that they have down in their bank deposit or be a cash buyer. So that means you're going to have to go and get a loan approved. It's a mortgage, and that's the only way you're going to be able to buy the house. So in the contract, there's a specific clause that addresses what is known as the mortgage commitment contingency, meaning you're going to get a loan for a certain amount. I'll give you an example. You're buying a house for $500,000, probably not in Brooklyn, maybe Long Island, and you want to put 20% down. So you're saying, I have $100,000. So in essence, you need a mortgage commitment for $400,000. That will allow you to get enough money from the bank to buy this house. So when you're looking at the contract, you want to make sure that the mortgage commitment amount is for $400,000 for you to buy this property. Otherwise, you won't be able to buy it. So that's important to pay attention. The other thing is that, these days, it could take more than 30 days to get your mortgage approved. So you want to make sure that you have enough time to get that mortgage approved, because if you don't, you have to notify the seller's attorney and let them know that either you need additional time, or that they should give you an extension, or that perhaps it's not working out, you can't get the loan approved. You need to think about your possibility of getting out of the contract as well. So again, the most important thing is related to the mortgage commitment. The second thing that I think is really critical and important is that you examine within the contract what are all the obligations for the seller in terms of delivering the premises related to governmental violations or ordinances. And you do that by writing a title search on the property. So your attorney needs to make sure that they run a title report on the property to find out all of the judgments, liens, violations that could come up on this property. Whether the homeowner got a violation, perhaps in New York City there could be ECB violations. In Long Island it could be something else related to what the town said that they did that they weren't supposed to do. So that's really important. You have to pick up on that. You need to make sure that your attorney does his job or her job to make sure that the title is going to be clean. That's really important. You want to make sure you get clean title. There's no violations. There's no government obligations or ordinances on it. I've been doing this for 10 years and I've seen so many strange things come up in terms of, open permits, or that ECB violations or judgments against a property or other issues that could affect the title. You want to make sure that's all clear. Now, that kind of segues into the third point, which is related to conditions for closing. That's an important section of the contract because perhaps you're buying a 2-family house. You want to make sure that on the day of the closing, or prior to that, really ideally, that the seller is going to give you a certificate of occupancy, meaning a CO, for that specific property, whether it's a 1-family, 2-family. That's important to pay attention to, because you don't want to pay for a house that the seller is saying and listed perhaps as a 2-family, and then you look at the CO, it's only 1-family. And you need to make that determination, by examining and making sure that that seller does provide you the correct CO for the property, and other issues as well, such as, for example, making sure that all of the appliances are in good and working condition. Nobody wants to buy a house and realize that the toilet's not working, the plumbing's been backed up, the appliances, the stove, the oven, other things like that are not properly working. You got to get all those things addressed in terms of making sure that the seller is complying with that portion. Now, the fourth thing That's also really important. And I have a detailed conversation with my clients about this, is related to default and remedies. Meaning, what happens if you, as the buyer, default on your obligation to buy this property? For example, you've got the loan approved, everything is going good, and then something happens in terms of perhaps a situation where you can't go forward and you can't close right away, or something else where you realize I can no longer buy a house. It could be something as serious as losing your job, or perhaps you and your wife or somebody else that was co-signing saying I can't go forward, or they lost their job, something else that could affect where the lender wouldn't give you that funding. So in that situation, you need to have a conversation with your attorney about what happens if I can't go forward. How is that going to affect me? What are going to be my obligations? In that section, it's going to be talking about what are the defaults and remedies. So in that situation, if you can't go forward on this property, the seller will probably keep your deposit. So you have to think about what's the amount of money you're putting in that contract as the deposit amount, because you could potentially risk losing it. The same goes for what happens if the seller realizes all of a sudden this is a hot market and he wants to sell it to you for 500,000. Now he could 600,000. He's like, hey, I'll just break that contract. What are you as the buyer going to do to make sure that that seller sells you that property? Because you don't want to go through that process all over again. So you have to understand and have that conversation with lawyer. What happens if that seller doesn't want to sell? How are you going to hold that seller accountable so you get that property as well? And the final point, this is something that's personal to me. Some lawyers are saying, oh, it's okay, we can do this. I personally think that you should get the property vacant. There should be no post-closing possession. Oftentimes, this may not be addressed in the contract, but perhaps the rider, but essentially the rider becomes a part of that contract. You don't want to buy a house, especially in New York City, where somebody's living there, whether they're tenants or the owner, and the owner says, oh, I need some time to move out, and I'll put some money in escrow. My advice to you, don't do that. Especially with tenants, it's really difficult in terms of the housing courts, whether you have to have a tenant leave or not. You don't want that to become your headache. Buy a property where you can move in right away and that the seller is going to deliver possession to you. So those are those 5 things that I think you should pay attention to when you are looking to buy a property. Of course, you want to talk to your attorney and understand your obligations of the contract before you sign it, and hope you all find your dream home and can buy it.